Your credibility, establishing that you're telling the truth at all times, is very important in any type of legal case. Your credibility is especially important, or even critically important, in a harassment case, because many harassment cases, or even most harassment cases, involve the so-called he said, she said situation, where you would have one version of the story of what happened as a victim of harassment, and the harasser will likely deny everything you say, deny all your allegations, or the harasser's version of the story is going to be very, very different from yours. It is known that once the lawyer on the other side, or the judge, or the jury hear anything from you that's incorrect, they will start doubting the rest of your story. And that's why, again, in all cases, but especially in harassment cases, it's very important to make sure that you maintain the highest credibility possible. Now, most people, most claimants in harassment cases, most victims of harassment are not trying to intentionally lie or mislead their lawyer or the court. They're simply making these little common mistakes that are driven almost by their human nature, that hurt their credibility and make them appear like they're lying, or like they're not telling the truth, or like they're not being precise, even if they did not intend to lie and they did not intentionally wanted to mislead anyone when telling their story and were making their claims. So here are a few tips to help you as a victim of harassment to make sure that you maintain the highest level of credibility, and it is impossible to doubt your credibility at any stage of your case. The first and the most important thing that you need to do is you need to make sure that you do not exaggerate your story. You do not insert your own thoughts, ideas, and suspicions into your harassment case. Many people, maybe most people, have this tendency to advocate on their behalf when they meet their lawyer for the first time, when they tell them about their case. Do not do that. Just deliver the facts and let the lawyers, let the system do the rest. Let me give you an example. Let's say you're a woman who is making a claim for sexual harassment, and let's say that your boss told you that if you want to get a promotion, you have to wear shorter dresses to work. Well, if he really said that word per word, then say that to your lawyer. You should not be telling your lawyer or telling anyone, you should not be telling at your deposition or in court or in any other forum that your boss told you that if you want a promotion, then you have to sleep with him, because that's something else. It's possible that that's what the boss eventually wanted. It's possible that that's what the boss thought about or fantasized, but that's not what he said. What you think, what you assume, what you speculate on is not evidence. The moment you make that exaggerated statement about something that hasn't happened, statement about something that hasn't been said, and later it's proven not to be true, then it's going to be trouble, because your whole story is going to be challenged as possibly not being truthful. And this also applies to other type of employment cases. This applies to discrimination cases just as much as harassment cases. Let me give you a common example. Let's say that you have a disability discrimination case and you're claiming that you notified your employer of your disability 3 days before you got fired, and you believe that you were fired because of your disability. And let's say that you had a conversation with your boss, with your supervisor, 3 days before your termination, during which you told your boss that you need to take a few days off because you're sick. And later you tell the lawyer that you told your boss that you needed 3 days off because you've been diagnosed with cancer and you needed a surgery. Well, get your story straight. What did you say and what did you not say? Do not try to make the case better than it is, because eventually these things will come out and they will hurt your case. The other thing that you can do to maintain your credibility at the highest level possible in a harassment case is to get the specifics, to get the details of your case, of what happened, as precise as possible. What happened exactly, who said what, exactly, under what circumstances, who was present, and make sure that you remember as much of the story as possible. And if you don't remember something, if you don't know something, you simply say, I don't know, or I don't remember. Because if you provide information that's not true, however unimportant it might be, it might hurt your credibility. Let me give you an example. Let's say you complained about harassment during your HR meeting, and you're being asked, well, how many people were present at a meeting when you complained about harassment? And you're going to say 5 people, and you're going to name all the executives of the company. And it turns out that only 2 of the executives were in the room, and the 3 others were absent, and they testified that they were not there. They had no idea about the harassment. It might or might not have an effect on your case, but it certainly doesn't make you look good. So, if you don't remember who was sitting in the room, if you don't remember, I don't know, what type of painting was on the room, if you don't remember something else that's not quite as important and not something that you can be expected to remember, do not provide that information. It's perfectly fine to say, I don't know, or I don't remember, if you don't know or if you don't remember. And if you're asked to estimate, well, how many people approximately were in the room? I think about 3 to 5 people. I don't remember exactly. It's much better than providing precise information, committing to a specific answer for people, and here are the names and here are the titles, to only find out later that some of them or all of them were not there. So, to maintain your credibility in a harassment case, make sure you do not exaggerate your allegations. You do not add to the story your own thoughts and ideas. And also, make sure that if you don't know something or don't remember something for sure, you simply say so. You say so to your lawyer, you say so at the deposition, you say so at arbitration or at trial. Nobody expects you to have a perfect memory. Nobody expects you to have a perfect case. I assure you that the lawyer you're working with does not expect you to have a perfect case, because he knows that perfect cases pretty much don't exist. They're always good facts and bad facts. And speaking of which, the last tip that I have for maintaining your credibility is this. Help your lawyer prepare your case by sharing with your lawyer any type of negative information, any information that can present a challenge in proving your case or winning your case, however insignificant it might be. Share it with the lawyer as early as possible so that he can be ready to deal with it. For example, let's say that you have this sexual harassment situation, and you're saying that whatever move your boss made on you was unwelcome. Maybe you had a few flirty text messages or emails a month ago or 2 months ago. The type of messages that might suggest that you're also interested in him. Well, if that happened, share them. Share these messages with your lawyer. Let him get ready to address this type of evidence and make sure that he's not blindsided and surprised by that evidence later. Another example, let's say there is a misrepresentation in your resume. Let's say you mentioned that you graduated from a certain school when you haven't. Or let's say that you listed a certain employer in your resume and you mentioned that you worked there for 3 years when you only worked there for 1 year. Share that type of information with your attorney. It will only help him, and it will also make a good impression on him. He will know that he is working with someone who is serious, who is trying to be truthful, and who is trying to be objective, who is not oblivious to all kinds of issues and weaknesses in the case. It will only make your relationship and your work with the lawyer better. So, put yourself in the opposing counsel's shoes. Pretend that you've been hired by the other side to attack your case, and see what kind of information you can come up with, and give all that information to the lawyer you're working with. I assure you that your lawyer is going to appreciate it very much. He's going to appreciate you, because it doesn't happen very often, and it will be very refreshing and very effective in preparing your case. Thank you.